corporate bankruptcy case in Catalonia, and a dispute over shareholder protection led to one of the court's most impactful rulings. At the core, the International Court of Justice had to decide who can protect the rights and interests of foreign investors. But while doing so, the ICJ ended up answering a much wider question. Can humanity itself hold rights? Rights that all states must respect in order to prevent, avoid, and punish atrocities? Welcome to International Law Unboxed, the podcast where we unpack legal concepts from legislation and case law and make them usable in the real world. I'm your host, Leonel Lisboa. This is Modern Echoes of International Justice, our 10-episode series on how decisions of the International Court of Justice continue shaping legal thinking on sustainability, business, and human rights. Episode 3: Universal Obligations and Corporate Shields. The Barcelona Traction Case. The reason I chose this case for this episode is because it is fundamental to understand business and human rights. In this episode, you'll learn about the rules that define if a company is from this country or that country, and this determines which are the rules that protect the company and also that the company has to follow. Also, you'll learn how a country can take the legal case of one person or a group of people to an international court, and, in my opinion, the most important contribution of this decision to international law. A good answer to the question: do countries have obligations towards all citizens of the world, or to just their own citizens? And then countries can do whatever they want with other people? So, in episode 2, we analyzed an advisor opinion, which is the International Court of Justice answering an abstract question of law that was asked by an organ of the United Nations. In this episode, we'll see our first contentious case of the series. The most classic structure of contentious cases is that you have one side, let's say, attacking or accusing the other side of a violation of a law that causes them some loss, some damage. And the other side is like defending itself. This is the most classic structure, and it applies to this case. The side that is attacking, we call applicant, and the one defending, we call respondent. In this particular case, Belgium is what we call applicant, and Spain the respondent. The official name of this case is Case Concerning the Barcelona Traction Light and Power Company Limited, Belgium versus Spain, 1970. But everyone just calls it Barcelona Traction. Remember what I just said about the classic structure of a case? You need an applicant and a respondent, and the applicant wants the court to recognize that the respondent violated the law and somehow caused some loss, some damage. This loss, this damage in law, we generally call injury. So, what was the alleged violation and the injury in this case? Let's examine the facts. So the company, again, Barcelona Traction Light and Power Company Limited, was a Canadian holding company that had operations in Catalonia, Spain. It operated the electric grid of the place. But most of the shareholders were Belgium. So after the Spanish Civil War and World War II, lots of things happen, and actually Barcelona Traction, the company, is not able anymore to pay its debts. In 1948, the Spanish courts declared it bankrupt and ended up transferring the control of the assets to a newly formed company, a Spanish company. The Belgian investors felt that they had their company illegally taken from them by Spanish courts and by the Spanish authorities using these maneuvers, and their company was given to this new Spanish company. After trying and failing to solve the situation internally in the legal system of Spain, the investors asked their own government for help. In response, Belgium took Spain to International Court of Justice, demanding reparation on behalf of its nationals, the Belgian shareholders. Before I tell you what the court decided, there is another concept we'll need to understand: the international jurisdiction of the court and how to stand before the court. The International Court of Justice is not like a national court, a domestic court. In a domestic court, if you, as an individual or a legal entity like a company, if you have a legal dispute with someone, that can be an individual or another legal entity, you can just go to court and get a decision, right? Of course, you generally need a lawyer, but that lawyer will represent you or the company. The ICJ is different. It is in the name, international. So the court decides cases between nations, between states. We're not going to talk here about specifically the jurisdiction, but how to stand before the court, if you can claim something before the court. So basically what Belgium is doing here is arguing that the Spanish courts and authorities did some things illegal to the company Barcelona Traction. And this was an injury to the nationals of Belgium because they are the main shareholders of the company. Then Belgium wants Spain to pay for it. In international law, we call this solution a diplomatic protection. When a country takes the cause of an individual or group of individuals and represents it internationally. Don't worry, we're going to go into that. Okay, now let's take a look at the decision. What did the court decide? In 1970, after years of proceeding, the ICJ dismissed the case. 15 votes to 1. Belgium lost. The court understood that since Barcelona Traction, the company, was registered in Canada and had its own legal personality, Belgium could not bring this discussion to the court. Actually, Canada could bring the discussion to the court, but not Belgium. The shareholders are Belgium, but the company is another person. A legal person incorporated in another state, entitled to the protection from that other state, not from Belgium. This is what we call in international law lack of jus standi, or the lack of legal standing. Belgium had no right to stand before the court, because whatever violations of rights that might have happened did not concern Belgium, the country of most of the shareholders, but Canada, the country of register of the company. This decision has enormous historical impact because of the consequences for the shareholders and because of the legal gymnastics that the court did in this case. And I say gymnastics with no negative connotation. Gymnastics is quite hard and requires both talent and discipline, and when done right, it is a spectacle to be witnessed. And this is exactly the case here. Okay, so now let's take a look at the three most important elements of this decision. We're going to talk about the rule of corporate nationality, the limits of diplomatic protection, and the obligations towards humanity. Time for the main legal highlights of the decision. Let's first take a look at the rule of corporate nationality. The court reaffirmed a formal test. A company's nationality is determined by where it was created and registered. But while doing this reasoning, the court gets very reflective, very philosophical, let's say, about what actually is a company. So think with me. A company is a legal fiction, right? It is a social invention. It is the idea that there is something else, something more beyond just the collection of workers, offices, trucks, machines, contracts, products, documents, money, the owners, and a name. When you put all these things together in a specific way, you have a new legal entity. You have a company. This company is a new person, not a natural person like you and me, but a legal one. We call it a legal entity. And I said, put these things together in a specific way because this specific way is defined by the law. Which law, you might ask? The law of the place of incorporation, the law of the land where you register your company. Of course, there are a million other details, and corporate law takes care of that, but for the objectives of this episode, let's take a look at the general rule. If you or anyone follow the specific rules of a particular place, you can create a company there. And as the court noted in paragraph 40 of the decision, Barcelona Traction is a limited company. This chosen legal structure actually separates significantly the shareholders and the company itself. I know it is true that the way you look at a company makes you see different things. So when you look at a specific company, you might see the workers and the products of their work. Or you might see shareholders and the means that they apply the money and how they get some profit, some interest. Or you may just see a corporate name and a bank account in a tax haven, whatever. What the ICJ decided is that a company is not just the sum of its parts. Legally, it is something else, and this has legal consequences. Entertaining this idea in paragraph 45 of the decision, the court explains, and I quote in relevant part: even if a company is no more than a means for its shareholders to achieve their economic purpose, it enjoys an independent existence. Therefore, the interests of their shareholders are separated from those of the company. End of quote. This means that when Belgium argues that the shareholders had their rights violated by Spain, there is no legal standing because the company and their shareholders are not the same. They are separate things. Legally, they are separate people. The Belgium shareholders have rights of protection under Belgium law, and while the company has rights of protection under Canadian law, and those rights could be argued by Canada, but not by Belgium. A little bit like real people, fictional persons, like companies, have the nationality of the territory where they are incorporated, where they are created and registered. This is the rule of corporate nationality. You might be thinking now, well, but we live in a highly integrated, and some would even call it globalized international system. Is this still the rule? Yes, it is. And this has major implications for business and human rights. This rule of corporate nationality has very strong implications on the protection of international investments and on holding foreign companies responsible for their human rights violations abroad. We're going to go a little bit more in depth on that in the diplomatic protection part and also in the loophole segment of this episode. So, as we have already seen in this episode, the International Court of Justice, when deciding cases, only solves disputes between states. If real humans like you and me, or legal entities like companies, have had their rights violated by another country, they can, of course, try to solve the situation using the legal domestic system of the country. But sometimes it doesn't work. So, what if countries just refuse or deny you your rights anyway? Well, then you can ask your own country to fight for you, like the Belgian shareholders did. This is legally called diplomatic protection. As the court has explained in paragraph 36, and I quote in relevant part, it is the bond of nationality between the state and the individual which alone confers upon the state the right of diplomatic protection. End of quote. And the same applies to corporate nationality. As I said in the beginning of the episode, if someone causes you some loss, some damage, we call it injury. So if there is an injury to you, generally you have the right to a reparation, a compensation. Whoever caused that injury to you has to pay for it. In this case, the facts are that Spain allegedly caused injuries to the company Barcelona Traction, and that would give rise to the right to compensation. Okay, but compensation to the company, not to the shareholders. When you own a company or a part of a company, you are taking up the risks that you might have some gains or some losses with the company. The company might succeed or fail for many reasons, and the shareholders get the profits or the loss when it happens. Since the company and shareholders are separate, the rights of the company to compensation do not correspond to rights of the shareholders. In fact, the shareholders are running a risk. They are investing their own money, and in this case, they lost it. As the court said in paragraph 44, and I quote in relevant part, if something wrong is done to the company, this frequently causes prejudice to its shareholders. But the mere fact that damage is sustained by both company and the shareholders does not imply that both are entitled to compensation. End of quote. In other words, even if Spain had against the law caused the company Barcelona Traction to fail and then go bankrupt, that is an injury to the company, not to the shareholders. In a very, very consequential part of this judgment, Belgium argues that the shareholders have interests, and those interests were injured. The court decided that interests are not rights, and there is no protection in international law for interests, just rights. This understanding leaves investors significantly unprotected, and investors don't like that, and they will strike back. Before we look at the obligations towards all humanity, let's take a look at the loopholes of the day. Loopholes of the day: how to protect your international investments, and how to catch a corporate criminal. So here's the first loophole. In this case, the court made very clear that shareholders cannot use just international law in general to claim compensation when a company itself suffers harm. In the paragraph 52 of the decision, you can understand that if there is no additional rule in international law, like no specific treaty, the investors have no protection against the acts of the state where they invest, the actions that are directed to the company. More, the court then indicated a solution in paragraph 90, and I quote in relevant part. In the present state of the law, the protection of shareholders requires that recourse be had to the treaty stipulations or specific agreements directly concluded between the private investor and the state in which the investment is placed. End of quote. This decision explains that without a specific treaty, if a country illegally causes injuries or destroy a company owed by foreign investors, these foreign investors have no way to judicially go against that state and at least get their money back. And you know what happened, right? This consolidated and propelled the trend to have investor-state treaties, creating rights for these investors under international law. These treaties generally establish the authority of international arbitration to solve any of the problems that might happen. These investor-state treaties change the game, and if a company controlled by foreign holders gets injured by the state where it operates, then the state has to pay back to the investors. And this is going to be discussed in an international arbitration procedure that we can discuss in another episode. But the problem here is, what if this company actually violated the law, committed atrocities against the human rights, like throwing pollution on rivers, affecting thousands of people, or engaged in forced labor? Can the state protect its own citizens against the delinquent acts of a subsidiary of a foreign company? This brings us to the second loophole of the day, the problem of international liability for companies. If companies get international protection, how do we hold companies accountable when they cause harm, when they destroy the environment, or violate human rights? Think of a transnational mining corporation with dozens of subsidiaries in different countries, and a local subsidiary in one of the countries is operating the mine. If that subsidiary violates human rights or destroys the environment, victims might sue the company and bring the situation to domestic courts. And let's say the victims win the case, and we have the right to compensation. In cases of mass atrocities or severe environmental damage, this compensation will inevitably be quite high. It's a lot of money. But what if the company doesn't want to pay? Well, normal people like you and me and responsible businesses, they pay when they are ordered by a court. But a delinquent company engaged in environmental degradation or human rights abuses will often do the wrong thing and avoid paying the compensation. Let's use an example. Imagine that you live in a country full of mineral resources, and a foreign mining company comes and establishes a mine there. This new mine is probably operated by a locally established company, a subsidiary of that foreign company. Then you find out that the rivers around the mine got contaminated by the pollution from the mine, causing severe environmental degradation, diseases, and many people, mostly children, die as a consequence of that. Well, your country needs to impose consequences on the mining company and get compensation for the victims, and also get some money to pay for the process of restoration of the environment, right? And this will be a lot of money. So then you bring this case to the court, you have a legal battle, and in the end, the courts decide that the company has to pay hundreds of millions of dollars in compensation and punishment. If the company refuses to pay, the court can just order a takeover of all the money or the assets of the company, sell them if needed, and then pay the victims and also pay the punishment. But what if this local mining subsidiary has not enough money and no assets? What if, when the court order arrives, the company has sold everything and transferred all the money to the parent company? Can the courts of your country then order the banks in the investor country to take over the money and send it to your country? Unfortunately, not. This is the current state of international law. This is the loophole of international business delinquency. It costs a lot of money for responsible businesses to invest abroad, taking the safety measures to respect human rights and protect the environment. But if you are an irresponsible investor, you can just violate the law abroad and be protected in your own home country. With few exceptions, there is no legal way to catch this kind of investor. And thinking only in financial terms, if there is a good chance of profit and probably no punishment, what are the incentives for the investors to do the right thing? But there is a lot of effort to change this and bring justice to victims and create examples of these delinquents, so investors don't go in that direction. There is currently an international treaty being negotiated in the United Nations, and some legislation waves in places like France or the European Union. But none of this has matured yet to example level. So here are the two loopholes explored by international investors. Now, let's get back at the third part of the decision, in my opinion, the most important part. So let's follow the reasoning of the court. When analyzing the case, the ICJ explained that the obligations to respect these interests of the shareholders, creating rights for them, were not universal, but they were between parties. In other words, if there is a treaty between investor and state, they are parties to a treaty, and then they have obligations inter partes. But what about any other relations between the state and a foreign individual? If there is no contract, no treaty, is there simply a legal vacuum with no rules and countries can do whatever they want? Here, the position of the court is very clear. Of course not. There are some obligations that are erga omnes. In other words, they are obligations towards all humanity. In this phrase, erga means literally in relation to, and omnes means all people, so obligations towards all. And what are these obligations? They are the prohibition of aggression, meaning offensive war, genocide, slavery, and racial discrimination. The literal wording of the court in paragraph 34 of the decision is like this, and I quote in relevant part. Such obligations derive, for example, in contemporary international law from the outlawing of acts of aggression and of genocide, as also from principles and rules concerning the basic rights of a human person, including the protection from slavery and racial discrimination. End of quote. This was the first time that the ICJ explicitly recognized obligations of states towards all humanity. And these obligations towards all humanity are still very relevant today. Let's take the example of the prohibition of genocide. You can see an example on the ongoing case South Africa versus Israel before the International Court of Justice, where South Africa invoked in 2023 the prohibition of genocide in face of Israel's actions in the Palestinian occupied territory. In this case, the jurisdiction of the court is based on Article 9 of the Convention Against Genocide, but the legal standing of South Africa is exactly based on the obligations erga omnes of Israel. The State of Israel has both universal erga omnes obligations regarding the prohibition of genocide towards all humanity and erga omnes partes obligation towards all the members of the convention. The argument from South Africa and dozens of other countries that joined the case is that even if there is no specific citizen of their country suffering genocide at the hands of the State of Israel, South Africa and each country that joined the case have the legitimate legal interest to have the prohibition of genocide respected because they are members of the same convention. We are all injured when genocide happens, no matter against whom. This shows how interconnected international law is. A corporate and bankruptcy case in Europe can have consequences for the protection of human rights against genocide everywhere. This is why this series is covering these decisions of the International Court of Justice, because many times they are about you and me and everyone. Chasing the thread. As I was recording this episode, my cat scratched her left ear and looked at me many times with a puzzled face. Then I think she asked, "Hey human, why do you keep saying these weird words? Use standi, erga omnes, etc. Which language is this?" Well, as you know, Fumasa, humans have many languages, and in many specialized fields of knowledge, there are some cultures that have some predominance. One of the consequences of that is that here and there we have a tendency to use some buzzwords from the original language of that element of culture. For example, if you're a tech person or a finance bro, chances are that you're probably, whenever you're speaking any language, still gonna use some words in English. If you're a chef, probably some words in French. If you're a musician, probably some words in Italian, and so on. So in law, it is the same. Some words in Latin. But the problem is, almost nobody actually speaks Latin today. So in practice, we kind of say the Latin words with the accent of the language we are speaking at the moment. So how do you pronounce them? Well, we just adapt to the language we are speaking. I'm Brazilian, so whenever I'm speaking Portuguese, I'm gonna use words in Latin and speak them with my native Brazilian accent. When speaking English, we have to pronounce them in a way that the others can recognize them in the middle of the sentence in English. So in English, we pronounce kind of erga omnes, use standi, use cogens, not trying to super sound Latin, but kind of English. So this is why you're hearing these strange words from Asa. And after this explanation, my cat looked relieved, yawned, and got back to her very important nap. So, this is episode 3. I hope you have enjoyed this journey through a case that starts with a dispute for international shareholders and ends up reshaping international law. With the main legacies of 1. A stricter rule in corporate nationality and diplomatic protection, which indirectly fueled the rise of modern investment treaties and 2. The recognition of erga omnes obligations, universal obligations owed to all humanity, prohibiting the gravest atrocities. But before we go, some reading recommendations. So if you want to learn more and go deeper in the case, I have 2 reading recommendations for you, 2 articles. The first one is Protection of Shareholders' Interest in Foreign Corporations, Barcelona Traction Revisited, published in 2023. It was authored by Rebecca McManaman and Professor Michael Weibel. The second one is On Obligations Erga Omnes Partes by Professor Pak In S. Chow, published in the Georgetown Journal of International Law in 2021. Details and links for these articles are in the transcripts of the episode. Links available in the show notes. If you have any comments, questions, suggestions, or ideas, please let me know. You can drop a comment in your podcast player or reach out to me with social media or even an email. The details are in the show notes. Next episode, we follow the Danube River into the court. A dispute about dams and diverting waters becomes a lesson about sustainable development. Join us, won't you?